You testified earlier that you reviewed emails between my client and her daughter.
I did.
Okay. Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Jibbers to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markel's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendi Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph that he knew she had these accounts because he managed one of them, and he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendi filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so dollars. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially, is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied.
Mm-hmm.
Did my client, in the emails you review, appear to push back on Wendi and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Is it possible to undo this? And then Wendi responded, I think at the end of that, Mom, I'm at peace, I'm good. And then they dropped off. There was no more communication that I saw between them.
Certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they're very involved, I'll ask to meet with them and bring them in, because what I don't want are third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is valid or is going to help you. And we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position, and maybe theirs will change.
Now, you were provided with a number of emails that Wendi was sent by her mother. Did you see evidence that Wendi shared those with Kristen Adamson?
I saw no evidence that Wendi shared them.
Okay. And did you speak with Ms. Adamson about that?
Yes.
Okay. Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendi Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days, with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for, and that was to last 3 years, and then it went into 50-50. I think that got the youngest child to school, maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, the division of child care, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, child care, insurance, health insurance, and parenting time.
Exactly, exactly. And then Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision-making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision-making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that, by agreement.
And you mentioned keeping the boys kosher. Was Wendi Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendi Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markel granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendi Adelson required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say you need to go to your therapist and follow their advice.
Was Wendi Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements, because kids don't want to see their parents fight every birthday. Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement? No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendi a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendi Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or income or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendi Adelson?
Yeah. Yes.
Now, later,
But it was very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those, and they got a very typical marital settlement agreement.
So from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.